from the News Channel 5 network. This is Score on Business.
Hey, welcome to Score on Business. I'm Pete Hendricks. I'll be your host today. I'm also a serial entrepreneur. Many prospective and entrepreneurs aren't sure where to start, so we'll start providing a tip on each show. Also, Score offers low-cost classes and no-charge counseling specifically to guide folks through thinking about starting and succeeding in business. The first step would be either attending our Start Your Business workshop or reaching out to Score for an initial appointment. Buying a franchise also a good choice for many, though you have to do your homework. We provide low-cost seminars most Saturdays and some evenings. Typical seminars are Start Your Business, Write Your Business Plan, Develop Your Business Model, Financial Projections, and more. There's scorenashville.org is our website, and click on the Workshops tab. So, your tip for this show, there are many resources available for entrepreneurs. Stack the deck in your favor by taking advantage of them. In Nashville, Score, the Entrepreneur Center, Launch, Tennessee, the Small Business Development Centers are all available. Okay, so our first guest is Jim Cartilia with Patterson Law. So Jim is a shareholder at Patterson Intellectual Property Law, the largest IP boutique firm in the region. Jim has practiced patent and trademark law for over 30 years and literally filed thousands of patent applications in the U.S. and internationally, and you've done a lot of international work. So thank you for being here.
My pleasure.
Yeah. So tell us a little bit about Patterson Intellectual Property Law and how you all assist your clients.
Well, Patterson IP is a 21-lawyer boutique IP firm. All we do is intellectual property, primarily patents and trademarks, with copyrights also. Mm-hmm. Most of our attorneys, 18 of our 21, are registered patent attorneys. And we help our clients really across the gamut of intellectual property protection. We advise them on the best routes to take, whether they want patent protection, design patents, trademarks, copyrights, what would be the most efficient for their business and their needs. Mm-hmm. And then we also have a large litigation group also, right, if unfortunately it gets to that.
Yeah, well, of course, we always hope it doesn't. So many people will come up with a product and maybe do a prototype and immediately begin work on getting a patent. What are some of the realities they may not realize?
Well, unfortunately, there are a lot of them because it's kind of an arcane field if you're not in it all the time. A couple of things to be aware of. Timing is critical. So if you're interested in protection in the U.S., you have to file a patent application within 1 year of your first public use, your sale, offer for sale of your invention. So you've got to be aware of that date. Now, if you're interested in filing overseas, whether it be Europe, China, other countries, you have to have your patent application on file before any public use, sale, disclosure. Right. So you need to be aware of that as you're trying to market your invention, that you could be losing rights if you haven't gotten your application on file. Okay. The other thing to be aware of is a lot of inventors hear about something called a provisional patent application.
Yes.
You've got to be really careful with those. A provisional patent application is a placeholder. So if you file a provisional application, you can do it inexpensively, but you still have to file your full patent application within 1 year. So you're still going to be spending the money for a full application, you just delay it a year. Mm-hmm. And a provisional application is very limited in its protection. There's no protection at all, and the rights it gives you are very circumscribed by exactly what's in it. So there's a bit of buyer beware when they hear, well, I can get you a patent application very inexpensively. You need to know exactly what that means and what you're getting with that inexpensive patent application.
That makes sense. I think I don't know that much about patents. What I have heard is that you're a a true patent, you're looking at 10,000 plus, and maybe plus plus.
That's for really that's for the filing, including the government filing fees. After filing, there are actions you have to take with the patent office. So the patent office comes back and says, your invention was not patentable. And they do that 99% of the time. In fact, you want them to do that. If they don't say your invention is not patentable, maybe that means you haven't tried to get as broad as you can. So when the patent office comes back, you then have to respond. And the response usually costs $1,500, $2,000, $2,500. So that can happen 2 or 3 times. So the price can really add up, and at the end of the day, you're really probably looking at $20,000. And of course, there's no guarantee you'll get a patent at the end of the day. So it's not for the faint of heart.
Yeah, and I guess people need to realize if you're going to be paying $20,000 for a patent, you have to, before you ever make any profit, you have to sell $20,000. You have to earn $20,000 in profit.
Exactly.
Yeah. So when are cases where people really need to go ahead and realize, hey, this is a great idea and it's time to pony up, this needs to be patented. If you're going to do this, you need to be prepared for the roughly $20,000?
Well, one thing to consider is it can be awfully difficult to get financing if you don't have a patent application, unless you're dealing with a commodity product. If you have a unique product, especially if the barriers to entry to a competitor are not very high, then you've got to be very careful that you're protecting yourself and you're preventing a competitor from coming in and taking your research and using it for their own, which they're free to do if you don't have any kind of protection on it.
Okay. So there's more to intellectual property than patents for products. Can you expand? What else is there besides patents, and tell us a little bit about that?
Sure. So there are patents. First of all, we're talking about utility patents now, patents on a function, and there are product patents, so on the actual product, and there are also process patents, whether they be process for making the product, process for using the product that you can protect. If there's some software or control systems around the product, you can patent the software, you can copyright the software as well. There are design patents. If your product has a unique design or feature, ornamental feature, you can protect the design. And then of course there are trademarks for your name, your particular branding, even things like the shape of your product. You can try to get trademark protection. So you can attack the problem from different directions depending on what's most efficient for you.
So we're here in Nashville, which of course is the where so much country music is. I guess when people are writing songs with that would be a copyright, and if they hit the big time like everyone hopes they do, then the T-shirts and the bobbleheads and all that stuff, that would be is that a trademark or a patent or a? For
the most part, that's trademark. Okay. You can get some design protection depending on what it is, the bobblehead idea, if they're different enough. For the most part, that's trademark and possibly also copyright.
Okay. So how much protection does a patent provide? And a little more specifically, I mean, a well-done patent, I'm sure does, but if somebody is an entrepreneur and they haven't hit the big time, money is going to always be an issue.
Sure.
What about you get the patent, then you have to defend it, and what do people need to be prepared to spend in order to defend if they need to?
Well, it's a big number. A full patent infringement lawsuit can easily cost multiple $1 million at the end of the day. They take 3 years or so to go to trial, so it's a very expensive process. So it's helpful to have a licensee, for instance, that you've licensed your patent to make the product itself. You also have to be aware of the scope of your protection. So in a patent, at the end of the patent has something called the claims. and it's actually the claims that define what you're protecting. So you have to be aware of how broadly that is, because an infringer can look for ways around your claims to put in alternatives possibly that aren't covered. So you've got to be a little careful when you see someone coming out with a similar product that based on the scope of your claims, they actually are infringing your patented invention.
Okay, awesome. Thanks so much, ladies and gentlemen. We're going to take a break and we'll be right back. Thanks.